you know, penalty against children has to be much more stringent.
Yes,
It should
Niranjan
be 250. Thank you, ma'am.
Thank you, Madam Vice Chairman. Chairperson, sorry, ma'am. I have one serious objection in relation to the bill, and which I want to ventilate to the Honorable Minister personally. This seems to be like a conspiracy against lawyers because the language is so simple. Normally, we lawyers, we use the expression a lawyer's thicket. The language is complex, then the lawyers tend to make hay. Now, I think the Honorable Minister wants to keep the lawyers out of business. My friend Mr. Amar Patnaik, Honorable Member, had mentioned that another very interesting feature of this Act, Madam, has been that they have used illustrations, which after a very long time, when I am referring to laws very regularly, I go back to Contract Act of 19th century and a few of the very old laws where illustrations would be used. This Act uses illustrations for explaining the point, which even as a senior counsel, I found it very useful because some of these terms are very new to most of us. So when I saw the illustration, I could immediately understand what the section meant. So this is a very significant feature of the new legislative policy that the central government has undertaken. I compliment the Prime Minister, the Honorable Minister and the government. Ma'am, I think the bill starts off on a very interesting and important point where it treats the person receiving the information as a fiduciary. So this is in the nature of a trust. So I think that itself sets out the context in which how when information is shared by an individual, what is the responsibility that the person who is getting the information ought to discharge. So the use of the expression fiduciary in one quick expression sets out the whole context of the responsibilities that are placed on them. So this is again very laconic and very quickly explaining the entire responsibility on the person. Now, without deviating from the architecture of the Act, Madam, as I mentioned, the Act is simple, it is principle based, it does not offer too much of complexity, but I think a few areas can be improved without deviating, as I mentioned, Madam, from the architecture of the Act. One, I have an equal concern as Honorable Member Mr. Patnaik mentioned, notwithstanding the Honorable Minister's statement that privacy would be fully protected, Puttaswamy judgment of the Honorable Supreme Court would be fully covered. I would as a lawyer still be little worried, Madam, that the power which has been granted of exempting the government is little sweeping. It possibly is capable of a misuse at some point of time in future. But I also find, Madam, that clause 37 of the bill enables the government to issue further directions to giving effect to the provisions of the Act itself. So if this power can be used, clause 37 can be used, because I welcome the Honorable Minister's statement that no part of Puttaswamy judgment or the right of privacy as a fundamental right is intended to be breached. So we put at rest any worries or qualms on this front if certain directions can be given in the nature of guidelines or any other manner that the Honorable Minister may deem fit. It may set at rest a lot of these misguided apprehensions possibly. Then, Madam, the second feature that I find is in the cross-border processing that has been restricted in certain sense. Clause 10(2) states that this Act would be applicable for the processing out cross-border of any information only if goods and services are provided in India. Now, this may take outside the fold processing of information for any potential harms that may eventually be inflicted on India. So apart from the Act being made applicable when goods and services are rendered in India, I would suggest that the government may consider whether they also need to include the mischief of any harm being visited upon any citizens or persons in India by a processing of the Indian data, citizens' private data outside India. Then the fourth point, Madam, that I wanted to mention is with regard to the provisions relating to children. Clause 9(5) provides that the central government may, if it is satisfied that a particular data fiduciary has maintained a particular safety threshold, then specific to that data fiduciary, the central government may lower the age from 18. Just very quickly to give the references of other countries, ma'am. UK and US have an age limit of 13 years, which has been looked at the threshold age for children to give consent. EU has 18, but member states can reduce it to 13. Possibly India has taken 18 as the age because that is the contractual age for the purpose of a person giving consent to enter into a contract. But while that may be, I am suggesting that the central government power, instead of it being data fiduciary specific, it could be sector specific. For instance, madam, if in education, if they want to reduce, because a lot of children are now using data for the purpose of educating themselves, an education sector, a particular gaming sector which is not staking money, if sector specific power is exercised by the central government, a lot of central government responsibility can be given to the data protection board with regard to data fiduciary specific exemption for reducing the age. So central government sets out the areas where the age can be reduced, and the data protection board will grant permission to the data fiduciaries which maintain that safety threshold. Then madam, one other important thing that I thought I must bring the government's attention to is the exemption provision for data fiduciaries, class of fiduciaries or startups. Now this should not be misused, because a potential big data aggregator could set up what we call data mining startup. The only purpose of a startup will be that it will call itself startup. It will mine data if there is an exemption granted to all categories of startups, and use that data for the purpose of channeling it for some other purposes. So some of these exemptions that are likely to be granted may have to be conditioned by specific conditions that may be mentioned. Then lastly, madam, the concept of consent manager is a very welcome step, because it will be difficult for individual members, madam, to start.
You have 1 minute to conclude.
Yes, ma'am, I have 1 minute. I'll finish it in 1 minute, ma'am. The consent manager, this concept is a very welcome feature, because what may happen is lot of people could then grant that right to a consent manager, but some of these provisions relating to how a consent manager would then operate need to be fleshed out little more. This is an enabling feature in the Act. It is welcome, but as I mentioned, madam, that it may have to be fleshed out a little more. So, ma'am, I would compliment the government for coming up with a progressive light touch regulation. I know that the government is testing the waters. It is reposing trust on a wide variety of factors. I'm sure the government would come in and make more stringent provisions if this trust is going to be breached by any of the persons. So, for a starting step, I think we have a first-rate legislation, and I compliment the government, and my party fully supports it, madam. Thank you.
Shri Kanaka Medala.